Thank you. Is that on? Yeah, okay. I'd like to welcome two speakers, Nicola Beswick, who you would hopefully remember from previous speaker at an annual general meeting of ours. At an annual conference of ours, my apology. And Julie Chambers. So Nicola is financial expert, and Julie is a practicing lawyer from Chambers Robinson Gill, who specialises in estate planning. And we thought it would be a good idea to have a presentation about why it is important for people like with MS and similar conditions to have a will and powers of attorney and other similar documents in place. And that's not an age-based requirement. It's a requirement that should apply and should be recognised by everybody. And I contacted Nicola just to see if she was able to help, and she kindly offered to be part of the two of them who would come and speak today. So I'm going to hand over to Nicola and Julie. Thank you.
Thank you. I think I'm the one who's speaking today. Nicola's in financial planning. I'm a lawyer who practices in estate planning. So it's Robinson Gill is the firm. I'm not a partner, so please take the Chambers away from that. Firstly, thank you for having me here today. It is lovely to see people in person, and I understand that it's also being streamed. So thank you to everyone who's streaming and watching today. I'm a lawyer based in Box Hill at Robinson Gill. We're in Whitehorse Road, and I just want to start by saying this isn't legal advice. This is a general presentation on estate planning. So, first of all, who here has a will? Good. And we've got others there. Who knows where their original will is stored? Yeah, it's an important question because if somebody passes away, they need to know, your executor needs to know where your will is. The other question is, who here has looked at their will over the past 2 to 3 years to see whether it actually suits your current situation? I've got a few hands up there, that's good. I hope online there are a few hands up there as well. So I've really prepared this topic to give you some ideas for your estate planning when you're thinking about your own estate planning, or if you're talking to friends or family about it as well. And I hope you can have some takeaways from it. So I'm going to have you consider the following blended family situation. It's something that's come across my desk, and it's a bit of an example of what can go right and what can go wrong with a very simple estate. So, Dad has remarried for the 3rd time. His wife is 20 years his junior. She has 2 children from a previous marriage, and he has 3 children from his marriage. They own their family home as joint proprietors. He has an industry super fund, so that's like, it's one that's like Rest, Australian Super, something that comes with your work. Dad retired, and he's also inherited a significant amount of cash and shares from his mother's estate. So he has set up a self-managed super fund, which is governed by a trust deed, and that's where he would have sought the assistance from someone like Nicola. So 2 of Dad's children have fallen on hard times. They've separated, they're not in a good financial position. Dad has bought 1 house in his sole name with the intention in his will to gift that house to his daughter. The second house he has bought for his son, but he has bought it in his current wife's name and in his name, so Dad and his wife, as tenants in common. This is for the purpose of reducing land tax because he's got other properties. Dad wants to ensure that the 3rd remaining biological child is provided for as well, so it's all equalised in the will, and he will receive some money or shares through the estate. And he's not in a bad position, so he can wait. So, what could go wrong? Under the self-managed superannuation fund, he's executed a binding death nomination, which means that the super will go to his wife. He's happy with that. He's done that with the industry fund as well, so the wife's protected. The wife's the nominated executor of the estate, and also she's a joint director of the trustee company that governs and looks after the self-managed superannuation fund, so she'll step in and run it. The jointly owned home that he and his wife own will pass to her by survivorship. It doesn't even come into the estate. And any jointly owned shares and bank account, again, will pass to his wife. So she's protected and they're both happy. But what about these other two properties? Remembering one is in the deceased's name, but there's a provision under the will that it'll pass to his daughter. So that will take effect. But then there's other house that's owned as a tenant in common with his current wife, and his intention is that this house will go to the son. Well, he's only going to inherit half a house, and lucky him, it's going to be shared with his stepmother. So it's not perfect. And if she predeceases, it'll go to her children, so there'll be 3 people on title. So with advice, this can work, but those are the things that really need to be considered: the ownership of assets, how it'll come into an estate, and then how it'll be dealt with, and to ensure that the deceased wishes take effect. So, the other thing, of course, is have the stepchildren been provided for? Will they claim against the estate because he's left them a bit of cash? So with proper advice, it can work, and that's something that I always look at. That's a more complicated situation. So what, oh, Nicola, I've forgotten to, to tell you with the slides, my apologies. We're up to slide 4 now.
I kind of gauged where you were going.
Yeah. So what type of will is suitable? So there's different will structures available in Victoria to suit different wealth structures, and also to suit beneficiary requirements. So the will structure that would be recommended will depend upon what assets will flow into the estates and the needs of the beneficiaries. So a simple will, assets come in and they go to the beneficiaries, as long as there are no issues. Or there might be a testamentary trust structure which suits for asset protection, or if there's a child or a beneficiary who has special needs, for example, protecting NDIS payments, if there's some mental health issues, protecting some Centrelink payments, making sure that the beneficiary doesn't get access to capital and only gets income. That's another issue to consider. Or protection against bankruptcy if there's a beneficiary who has their own business, particularly a high net wealth, example, doctors, lawyers who have their own practices, architects. They want to be protected against bankruptcy in case something happens to the business. So that's where a testamentary trust can come into play. So what is this testamentary trust? Well, it's a trust that is established under your will. After you pass away, your will can create one trust or a series of trusts for beneficiaries. And it's a discretionary trust, similar to what you hear about in, many families have discretionary trusts throughout Australia, to control their business interests or investments, or to protect wealth. So the assets that go into the testamentary trust are not owned by the beneficiary, they're owned by the trustee. So that's the person who is appointed under this will to look after those assets. The will then provides that income and or capital can be distributed to certain beneficiaries, and it's about a 25-page will. It's quite descriptive, and it does guide the trustee as to what they can and cannot do. The assets are held on trust for a principal beneficiary, or it can also be for general beneficiaries to distribute income, spouses, children, grandchildren, the list can go on, and it depends on what you want and your family structures. But the trustee has a discretion to distribute that income or capital, so they don't have to do it. They can do it at their discretion, or if a beneficiary says, look, I need some monies to assist with something, then they can distribute. Pay school fees, pay bills, things like that. But it just protects that amount. So it seems complicated, but it does have those 3 important benefits. The asset protection, of course, protecting younger beneficiaries or beneficiaries who might be vulnerable, and also for taxation advantages, because the tax advantage will be that income will be distributed to minor beneficiaries at that lesser tax rate. So one question that always gets answered or gets queried whenever I do a talk about this sort of matter is, well, what if my children are separated from their spouse? Will that protect my estate from the spouse claiming against my child? Not fully, unfortunately. The family court can now reach into these testamentary trusts. It used to be that it could, but unfortunately, if there's a control position where the child is the trustee of their trust, the court will look at it that they will have access to those funds. So again, if that's an issue, you need some good legal advice about it. It protects your younger beneficiaries because you can nominate ages of what we call the preservation age of when those minor beneficiaries can receive their funds. Some people, and you can do this in a standard will, some people might say, I want part to go to my children at 18, part at 25, the rest at 30, for example. And that's to ensure that they don't waste it. Other people say, I don't care, they can have it all at 18. If they blow it, that's their fault. So just depends on your needs. The trustees can provide for the needs of a principal beneficiary as well. This is back to the testamentary trust. But they can refuse to give a benefit or money as well if they think it's not going to be used wisely. An example will be a child who may be drug affected or have a dependent substance use. It can also be things like a spendthrift, somebody who can't control their urges to spend. All those things come into play. So when preparing and reviewing existing wills, some common matters that I always look at are, first of all, who will be your executors? Who will be the people who will look after your estate when you pass away? Who will gather in the assets, pay the debts, and then distribute the funds under the will? Who will defend a will if there's a claim by a child or by somebody who's claiming more from the estate? It's a really important role. You should always think about an alternate as well, because often we appoint our spouses. A spouse may predecease or become unfit or unwell, or may not want to act because of grief. So it's a good idea to have an alternate or a couple of alternate executors in place. You might want to consider that if you do have your will in place, and I know most people in the room said they do, does it suit your current financial structure? Has your financial structure changed since your last will was drawn? There's something to think about. Values of properties go up. We might have a windfall from an estate, or lucky you if you win the lottery. So the ownership also includes company shares if you have companies or trusts that have a company share, real property, and we review any business and trust structures to look at that as well. An example is farming property. That's quite significantly gone up around the Ballarat area at the moment, and just for an example, over the years it's been rezoned, so that might be something that suits you, or you might know somebody who is impacted by that. The other thing is assets may no longer exist. Under your will, if you've gifted a property to somebody but you've sold that property, you're going to have a very disappointed beneficiary, or a beneficiary who might claim against your estate for that missing asset. If you've named charities under your will, you need to check whether they even exist still. If they don't, it may be that if there's not a clause in the will to take that into effect where there's a substitute charity, then you might find your executors have to apply to the court for direction as to where it should be paid. There's another issue that comes across my desk often about foreign assets. We're such a society that travels now, and people have foreign assets. That might be companies, shares, that might be properties overseas. I need to look at whether we can structure the Australian will to take that into account, or if we can't, we have the clients go and have complete a will in that jurisdiction to make sure that there are no problems upon their death with wherever those assets are going to pass. You might want to also consider if you've loaned monies to children during your lifetime, are they evened up to the children who haven't received monies during your lifetime? That's something that we look at as well. There might also be some estate protection requirements for beneficiaries with disabilities who are under the threat of bankruptcy I've covered that with the mental health issues where capital needs to be protected in an estate and that they're only getting income. That can be built into a simple will as well. You've heard of beneficiary death nominations for superannuation. There's binding death nominations and there's non-binding. That's one thing that we look at as well. If you have super, have you got a binding death nomination in place to ensure that the trustee pays the super where you want it to go? And that's where someone like Nicola can help out with financial planning. It's really important because that's a valuable asset because of the insurance under it. Often we've got a life insurance component. So another thing that someone like Nicola can assist with is a taxation advice. If super was to flow into an estate, if it's not going to be paid to a dependent, then you might find that whoever will receive it under an estate may be taxed, and it's not ideal. Life insurance policies as well can be used to be a really effective estate planning tool, where if you have multiple beneficiaries, the balance of a life insurance policy may be payable to one beneficiary outside of the estate, and that might even things up as well if there have been loans or gifts to children throughout their lifetime. So what if there is no will in place when somebody passes away? Well, that means you've died intestate, and that puts a responsibility on your family to find the appropriate person who would apply to the court for what we call letters of administration. From there, the estate will only pass under a legislative formula, and it may not be what you want. It might be, but it may not. So an example would be where the deceased leaves a partner and no children that belong to the deceased, then the partner would receive the whole estate under the rules of intestacy. That suits. But where the deceased leaves a partner and there are children that belong to the deceased, then the partner receives the whole estate again. The children don't receive anything. That may not be what everybody wants. But where they leave a partner and there are children that belong to the deceased but not the partner, then the partner will receive what we call a statutory legacy, and also, that legacy is indexed each year, so it goes up 1st of July. They also receive the personal chattels, interest on the legacy, and then half of the balance of the estate. So blended family, this may not be a perfect scenario. And then it goes on, it goes down the line if they've got more than one partner, if they've got two domestic partners, more children. So you can see why having a will is so important, because it can leave an absolute mess if it's not a simple family situation. So with estate planning, there's also another document I always look at to see is whether people have powers of attorney in place. Hands up here who has a power of attorney for financial or personal matters, and how about medical matters? Okay, that's half and half, that's pretty good. So these are documents that are drawn during your lifetime only. They cease upon death, and that's when your will comes into play. So the purpose of having a power of attorney and a medical treatment decision maker document, which is the new name for the medical power of attorney. Don't panic if you've got the old one in place, it'll still be valid. The purpose is to make sure that if you lose capacity and you can't manage your financial, personal and medical matters or medical affairs, then somebody can step into your shoes for you to assist you. I think everybody of any age should have this in place. COVID's a perfect example where people were in hospital. If you didn't have someone to look after you, family may have had to go to VCAT to get an urgent order to assist these people. They're also really important for an adult child with a disability who cannot look after their financial affairs. So an example is when that adult child turns 18, often mum and dad have done everything for them, but then who can sign for them? Mum and dad usually can't because the child is an adult. So it's important to have those documents put in place when you can. If you can't, and there's an adult child with a disability, then VCAT can be used, where an application can be made, usually by the parent, to be appointed as an administrator for financial affairs and as a guardian for medical matters. So that's a whole application, but it's something people don't usually think about because we look after our kids as much as we can, but when they're 18, they're often on their own and to their own devices. It also stops them being taken advantage of as well. It's really important. So what are these documents? The enduring power of attorney is a person who you'd appoint, and you can have alternates as well if that person can't act, to make legal, financial and lifestyle decisions on your behalf and in your best interests. So for example, selling and buying property, operating bank accounts and making decisions about what type of care you would receive in the future if necessary. That's, for example, going into aged care, or if somebody had to go into supported accommodation. It can be structured to start immediately, or it can be structured to start only when you lose capacity. And that means a doctor has determined you cannot make those decisions because you've lost the ability, mental capacity is what they call it. An appointment of medical treatment decision maker, or the old power of attorney, that only comes into play when you lose capacity, and that means somebody can make medical decisions on your behalf, to consent, refuse to consent to procedures, to consent to the use of pharmaceutical products or refuse that, and what type of palliative care you can receive. So this is not an advanced care directive, this is separate. This is whilst they can only make those decisions if you can't, and you can appoint up to 4. The old document, it was 1 and an alternate, but now they've changed it. You can have up to 4. The first goes first. If they're not available or can't, your second goes next, and so forth. So it's very handy, because the old document where you could only appoint 1 then an alternate, it was often I appoint my spouse or partner and then I have to choose which child. And people would grapple with that, particularly with big families. So advanced care directives are separate. Those are documents where a person can prepare this document whilst they have capacity to set out their preferences and instructions for medical treatment. Now, this is binding on the medical team. That's the difference. And if the person loses capacity and requires treatment, then that can be the first source of authority for how a person can be medically treated. It can be instructional, it can be a values directive, or a combination of both. I recommend, if it's something you're interested in, you talk to your GP, because I'm not a medico, I can't make those decisions. I could certainly set it up in a legal form, but it has to be witnessed by a GP and then another independent witness. So that's something to talk to your doctors about if that's something that is important for you. So here are some takeaways from you all for today. Everyone should have a valid will. Avoid that intestacy. Everyone should have a power of attorney, and I think everyone should have a medical treatment decision maker document, because we just don't know. I set them up in my 20s. Of course, I'm in the legal game, but I've seen people who've had dreadful accidents, road trauma, and if they had had these in place earlier, it could have saved a lot of grief for the surviving family. Everyone should also review their wills and powers of attorney. I think every 2 to 3 years, or if your financial circumstances change, just drag it out, have a quick look. If it suits you, put it back. If your appointed attorney dies under a power of attorney or becomes unsuitable, again, update it. Unsuitable means you may not get along with them anymore, or they might have lost capacity, or they might have done something where you don't want them looking after your finances. Obviously, well, it happens. If a nominated beneficiary under your will dies in your lifetime, you should review your will to check that it still will be suitable and that their share will go where you want. Usually there's that next level of beneficiaries that should be okay, but just have a quick look. If your executor dies or becomes unfit, again, unfit to act means you may not get along, they might have lost capacity, or you just think they won't look after you, or you might think it's too hard for them. If a beneficiary is vulnerable, nominated under your will is vulnerable through illness or through an accident, you should review it to see whether another structure should be in place for that sole beneficiary. And obviously, if there's a relationship breakdown, if there's a divorce, separation, then wills need to be revisited. So please go home, think about those questions that I've posed about the documents, know where your original documents are, contact the lawyers who did them, that's your first call, and make sure you understand them. Have a good look. If you don't understand them, go and talk to your lawyer who drew them, or find somebody. I can do it. Review your will so that you understand exactly what's going to happen. Finally, have that estate planning health check. It's really important where you go through every 2 or 3 years. Make sure they're consistent with your current wealth structure and that they reflect what you want. Thank you, everyone. I'm open to questions. I understand there might be some online or people might have them from the floor. Sure.
With a testamentary trust, the way I would understand it would be after you've died, then all your assets are pushed into a trust, and then the trustee would make distributions of income or capital, if they've so determined, to the beneficiaries.
Yes.
When those assets, 2 questions, when they're put into a trust, is there any tax that would be payable on that? Because you're not giving it to a direct beneficiary, you're putting it into a trust.
Yeah, so that's, I'm not a tax lawyer and I don't give that advice. I always say go to an accountant to see whether there's any taxable rollover that has come with the asset. For example, a capital gains tax that might attach to a property, or capital gains tax that might attach to shares, for example. So I can't give that answer. It just depends on what the person has when they purchase them.
My assumption is that there is, but I would need to check that myself.
Absolutely.
The other question...
Nicola's, she's a financier.
I can answer that question. It depends on the type of asset that's moved into that structure.
Yes. What if it's not the family home, there's like shares?
Yes.
Would there be tax that would be payable, capital gains tax on the shares?
Yeah, so when someone passes away, there's certain tax rules that come in within the state.
Yes.
And when it's moved into a trust, they essentially reset the
cost base.
Thank you.
Okay. So I'm assuming that the answer is yes. Tell me if I'm wrong.
Yes, but it depends, because sometimes if something's made a loss...
Oh yeah, if it's made a loss, then there won't.
Yeah.
Now, the other question was, I guess I've got another, just to think about it. When this goes into a testamentary trust, you've got to establish a trustee to look after that. Who would be typical in that situation? Who would be a typical trustee?
Yeah, so a trustee is contained within your will, so there's no new trustee that needs to be drawn up. It's all provided for. It's a 30-page will, and all the provisions of the trust are within that will. The trustee is the person you appoint under your will. To
follow that.
Correct.
To follow the directions.
Correct.
That you've put in your will. Okay. All right. Finally, if there's a property, say a flat or whatever, and you think, I'd like to buy a flat, and I'd like to eventually leave it one day for the kids or whatever, but can you do that in your name and then it's transferred automatically to a trustee? I suppose that would be how it would be done.
So if it's under a standard will, you might nominate that the children are the beneficiaries of that asset. It'll be transferred to the children, or they might decide to sell it. Otherwise, it'll be transferred into the trust. But again, it depends on how you've structured it, what other assets are there. We have what we call appropriation clauses in there, where such beneficiaries might take certain assets to have their share of the estate. They might not want property. They might not want a third or a half of a property. They might want cash only. So that's where we say go and get some advice.
That's why you're establishing a beneficiary trust. You've got to have it to live there.
Well, it depends on how many beneficiaries are there, because usually if there's 3 beneficiaries, for example, I'm just throwing it out there, there'll be 3 separate trusts. So it depends on what assets will go into those trusts.
Okay,
yeah.
Thank you.
That's okay. Yep.
I had a couple of questions. You said, where is the original of your will? Where should it be?
We usually hold them when we draw wills for clients. We've got a safe custody fire-proof room, and that's where we usually hold title deeds and so forth. So your lawyers should hold them. If your lawyers are no longer in existence, then the firm who bought them will hold them. If they've gone out of business or they've passed away, then another firm will have taken over, and we can contact the Legal Services Board to see where those documents are. Otherwise, people have them in safes at home. It can be dangerous having it at home because people have found them under floorboards, people have found them ripped and it can cause all sorts of problems. So having it at home, it depends on your filing system, and you want to make sure that no one's going to throw it away.
Is it worthwhile making several copies so that the beneficiaries have copies of them?
No need to give a beneficiary a copy of the will. It's usually the executor should be told where the original will is when somebody makes a will, and that means that upon the death of the person that they can then contact whoever's holding that original will to say that Nicola's passed away. I understand her will's at Robinson Gill. I'm just throwing it out there. It's not, but and what do we do? What's the next step? And as a probate service, what we do is we say we need the original death certificate. We can't release it to you until then because it's the property of the deceased.
Okay. You talked about the benefit of having an advanced care directive and saying that the medical team must obey that. So does that mean the advanced care directive takes precedence over other documents which might talk about that same sort of issue? Yeah,
so you want to make sure if you do it that it doesn't, that there are no conflicts with the medical treatment document. Financial, that's completely separate, but it's the medical treatment and advanced care. You want to be careful with what you do there and who you appoint, I think, under the medical treatment document to make sure that they're not going to cause a problem with any treatment that you do want. Yeah.
I mean, I know, for example, that people with MS have been encouraged to donate their brains to a brain bank, for example. I know, talking to friends with MS, they've said, oh look, I'm very reluctant to do that because my family wouldn't agree.
So donation of body parts is under your will.
Right.
So you can donate organs. People donate their bodies to medical science. If they're going to do that, they should work out where they want to donate it to, and there are forms to be filled out. For example, Melbourne Uni, I know clients have forms they have to fill out. It's quite rigorous, and there are some rules around how far away you need to be when you pass away that they have in place. So it is something that goes into your will.
Okay, and that would be binding on family members?
It's not binding. If they fill it out with the institutions, they might have something that's binding, but it's certainly not binding in the will. It's a wish. So things like, I wish to be buried or cremated, again, that's not binding. The best thing is to have a funeral plan, I think, that you've already prepaid, and usually the family will say, well, mum or dad did this, we better do it.
My last comment was really a comment rather than a question. You talked about making sure that the charity still exists and things of that nature. I was going to add that it's important, if you're donating to a charity, to make sure you understand what the function of the charity is.
Absolutely.
And the example I would use there is the issue a few years ago when we had serious fires and people donated to the Rural Fire Service in New South Wales, assuming that the money would go to the people whose houses, etc., were damaged in the fires.
That's right.
Only to discover that no, it couldn't. It had to go to the fire service itself.
That's exactly right, and that's a really good example. But that's not. We don't do that work for the clients. We always say, look, I can't recommend a charity because I can't be seen as obviously supporting a single charity. You have to go and do that work yourselves. But when they do, the usual ones are vision impaired, blind dogs, then cancer research I find comes across, and we make sure it's for whatever purpose as well. It might be for specific research. Eastern Health is another one that has come across my desk. Well, what do you want it to go towards? Otherwise, they'll do with it in a general fund. So they're things to consider as well.
Other questions? Anybody else from the floor?
Sure.
Basically, just one question.
Sure.
About the will. What are the steps? How should I go about? Like, how should I? Do I have to see a lawyer or?
We recommend you do. People do make homemade wills. They're not always correct because there are certain requirements in Victoria that must be complied with to have a valid will. So if you have a lawyer, go and talk to your lawyer and they'll give you some paperwork to fill out. And things you'll need to think about is who your executors will be, who your beneficiaries will be. Do you want to get any gifts of monies? Do you want to donate to charities? Do you have pets that need to be provided for? Things like that, but they'll go through it. But I recommend you go through a lawyer. Yeah.
Thank you. Now, so no further questions. In that case, I'd like to thank Julie very much for your presentation.
It's an absolute pleasure.
And thank Nicola for arranging it.
Being a support group.
Absolutely. I'm not an accountant. I can't give financial advice. So having Nicola here is invaluable. And I've actually I've worked with Nicola with estates before with some really tricky financial matters and said to clients, I know somebody who can assist you and give that correct financial advice. So that's always handy for lawyers to have.
And financial planners to refer.
Absolutely. Yeah. We have our own specialties areas.
If you bring some business cards with you,
I do have some cards, yes.
good to hand there, I think.
Sure.
Thank you.
You're welcome.
That question was from Michelle just asking Julie if she had any business cards with her, and she said yes, she did, so they'll be available. And the contact details will be on the
First slide, I think.
on the first slide
Yeah.
for those people who are watching now or those people who view this later as a webinar. Thank you again, Julie. Thank you.
You're welcome.
Thank you so much.
And thank you all for attending, and there will be sandwiches, tea and coffee available shortly. So please join us.
Thank you, everyone.